related tu yang kita tanya. Contoh macam ada
Okay.
part yang ada cases, for example, part yang setting aside of bankruptcy notice tu kita tak tanya dah. Okay, so I think that would narrow down your focus for the preparation of the test, betul tak?
Yes.
Okay, alright. So for the test, the topic to be covered would be the bankruptcy. So I explained to you just now what are the scope. Except those yang covered by the assignment. Okay, for the final examination, the topic covered would be winding up. Okay, so untuk saya rasa would be easier macam itulah sebab for the final examination, it's only macam allowed for maximum of 30% of the marks. So the number of the question allowed 2 question only. So kita fokus untuk winding up saja untuk yang tu.
Okay.
Okay. So that is for your final examination. Alright.
Okay. Thank you, Doctor.
Okay, you're welcome. Thank you for the question, Syahmi. Okay, kita ada berapa orang? 61. Okay, so far saya tak ada lagi macam yang respon pada saya sama ada tak boleh datang kelas, macam ada isu dengan connection. So is it everything okay with you all? Tak ada masalah apa-apa ke? So do talk to me if you have any question, any problem, any issues. Yeah? Sebab yelah, I know how it is when we are macam yelah, it's like macam distance, macam we are still getting used to this. Saya pun rasa macam still getting used to this. So still macam feel not really easy lah untuk, so I think it's much better to be in the lecture hall kan, in which I can see your response kan, boleh tengok ada muka berkerut kat part mana apa semua kan. So walaupun tak tanya soalan pun saya tahu aspek mana yang nampak macam respons yang macam need further clarification. Tapi sekarang saya tak nampak sebab semua orang tak buka video kan. Semua orang tak nak tunjuk muka. Syahmi yang selalu tunjuk muka, yang lain tak ada tunjuk muka pun. Okay. Alright, so I hope everything is well, but do talk to me if you have any issues, yeah? Alright, so okay, someone dah start recording ya. Okay, tak apa. Okay, so now saya share saya punya screen lah ya. So minggu lepas saya rasa saya ada problem with the sharing of this. Saya bila share mungkin a particular document tu, bila saya navigate through ada tabs tu dia akan jadi issues juga lah ya. So saya akan share the screen lah. Ya. Okay. So the topic today, okay, yang ni kita tengok kita punya slides, okay. So the topic today is the companies winding up. Okay, so kita dah habis lah topik yang bankruptcy. Yeah, so it's more than half of the semester, so kita focus more on the procedural aspect for the bankruptcy. Tapi untuk companies winding up ni kita buat cepat sikit lah, boleh kata macam mungkin kita ada dalam about 5 weeks kita ada, 4 weeks je sebenarnya, macam seminggu, next week would be given by Encik Azmi on the compulsory companies winding up. Okay, then you have also learned some part of this in your companies, yeah? Ada tajuk kan company law kan, yang terakhir sekali is the companies winding up. So you have some introduction to what is winding up. So here we focus on the macam procedure lah. So walaupun tak adalah macam in depth sangat pun within macam 4 weeks, 5 weeks we do not really have time actually to go in depth. Tapi apa yang kita nak fokus adalah more on the procedural aspect of it, yeah. And I think for the winding up, we do not really have time to do all of the procedures. Yeah, so saya mungkin nanti saya nak minta mungkin you look at the procedures and mungkin draw some kind of mapping as to what is the stages involved in the winding up. Yeah. Okay. So we look at the topic, yeah. Okay, so this is the topic, companies winding up. So for today, we will look at the law and procedure. Okay, and then a bit about the definition, what is it and what is the object, the aim of the winding up. Okay, and then before we look at the winding up itself, we look at how the companies may be rescued. ataupun the option available under the law before a company to be wound up. So it's what they call as corporate rescue mechanism. Yeah. Okay, this is the law. The laws are provided in Companies Act 2016. Yeah. Okay, and then the companies winding up rules 1972. In the preparation of these slides, so I forgot to check whether yang new rules has been available. So lepas ni kita tengok sebab sebelum ni tahun lepas we are still using the 1972. They are in the process of drafting actually for the rules. Tapi kita cuba, saya terlupa nak update whether the rules yang in drafting tu has been enforced. Ya, kita macam after this we will update ourselves. Okay, and then there is a special rules on corporate rescue mechanism. Yeah. Okay, that is this one, the rules for 2018. Yeah. Okay, and then these the rules, the two rules are macam what we call it specific for the companies winding up and the rescue mechanism. However, if there is any macam absence ataupun any kita panggil macam loophole, bukan loophole lah, is not a loophole actually, macam the provision is silent, for example, on certain things, so then we will refer to the rules of Code 2012. Yeah, so it would be applicable in the absence of specific procedure in the winding up rules and the CRM here, the corporate rescue mechanism rules. Okay, so those are the laws providing for the substantive laws and the procedural laws. Yeah. Okay, so that's the law. So next we look at the introduction as to what is the winding up. So you have done this before, and you have learned this in your company law, kan? So it's basically a process by which a company is dissolved. Dia panggil perkataan tu lah dissolve, maksudnya the company comes to an end. So dia punya perkataan yang digunakan adalah liquidated. Dia panggil dissolution of a company and liquidation. Yeah, so dissolution of a company tu is a process in which a company to be wound up. Okay, the word liquidation to refer to the process for the asset of the company to be liquidated and to be distributed to the creditors of the company. So that's the process. So bila keadaan winding up of the companies to would happen, so commonly bila dia financially distressed lah. Yeah, so when they are unable to pay debt, yes. However, there are still situations in which the company may be wound up, even though it is financially good. So later, bila kita bercakap tentang winding up, we'll see the situation in which a company may be wound up. Yeah, so financial distress ataupun macam inability to pay debt, tak boleh bayar hutang, is only one of the circumstances in which a company may be wound up. Okay, so that is macam a bit of introduction lah. Yeah, so the process ni involve the company's business is closed down. Yeah, the business stop, the assets are sold off. Yeah, okay, and then the purpose is to pay the creditors. Yeah, sama macam bankruptcy lah, bankruptcy process. The aim of the process is to pay the debt of the bankrupt person. Yeah. Okay, then the balance of the assets are distributed to the members of the company. Yeah, so if there is a balance lah of the asset. So members selalunya adalah macam shareholders of the company. Commonly they are similar person, tapi ada juga shareholders who are not members of the company. So yang this one you have learned in your company kan, company law. Okay, and then at the end of the process, the company cease to exist. So it is to be deregistered daripada yang proses incorporation kan, masa belajar masa company law tu, you learn about the process of incorporation of the company. That is macam nak get the company to come to life, to become a legal person kan under the law. So the end process of the winding up is to cease the company from its existence. Maksudnya dia deregistered lah, macam keluarkan daripada registration of the company. Okay, so that's the whole process about the winding up. So we will learn about this process The focus of this topic, the part of the subject is to look at the process. Okay, so before we look at the winding up itself, we will look at how to secure ataupun to rescue, selamatkan dia daripada winding up. So there are several options provided under the law. Ada 3 option lah. Yang existing, yang dah lama ada for the companies to rescue himself tu, mungkin dalam keadaan pandemik yang macam ni kan, COVID macam ni, banyak business going down, macam not doing well. So I think if you read the news, macam media prima pun dah macam arranging dia punya business kan. So AirAsia banyak orang kena has to resign ataupun ambil leave, for example. Those are macam part of difficulties of the company to deal with the situation. Okay, so in such a situation, the laws macam provides for macam mechanism ataupun option for the companies to consider to avoid being wound up. Macam if there is any possibility to save the company from being wound up, then they can consider this option. Okay, so there are saya tulis sini 2 option. Actually macam dia ada 3 option. Yang 2 option ni sebenarnya yang baru provided by the law in 2016 punya amendment kan, ataupun yang 2016 Companies Act, yang the new legislation for the company. Okay, the 3 options are the corporate voluntary arrangement. The word voluntary tu means macam it's the company itself yang initiate the arrangement. Okay, and then judicial management. So bila perkataan judicial tu, it's the court. So dia punya main role is given to the court. That is, the court has greater says rather than the company. Okay, so yang tu perkataan mungkin a bit like macam introduction. Okay, and then scheme of arrangement is macam already existing in the law for macam since macam yang Companies Act 1965. Okay, so kita fokus dekat 2 ni, dan scheme of arrangement tu nanti saya nak minta tengok dia sikit je lah. So basically ada sikit slide tentang ni, kita tengok later. Untuk hari ni kita fokus yang corporate voluntary arrangement and judicial management. So we look at the first one, that is the CVA dia panggil. So it is provided under section 395 to 402. Please read the provision later. Dia panjang juga provision tu. So I think it's better for you to read on your own. Dekat sini adalah is the summary of only. Okay, so when we talk about CVA, so it's the company yang propose for the arrangement of the company. So when we talk about arrangement of the company tu, is a kind of macam dia arrange in term of debt, in term of the shares, macam dia punya class of shares, in term of the value of the shares. So this involve macam interest of the creditors. Okay, in such a situation, so basic idea is that the company, so macam dia punya director lah, dia punya board of director yang propose to the creditors for a voluntary arrangement. So the kind of voluntary arrangement tu is basically macam commonly drawn up by what they call it as insolvency practitioner. Yang ni specialist lah. Dia insolvency practitioner is a person who is a qualified auditor, accountant, maksudnya orang dia akan check dia punya companies punya account, dia punya debt, so how what is the situation in which they can manage the debt again, so that will be basically drawn, dia punya arrangement tu will be drawn by the insolvency practitioner. Okay, so we look at these slides. So the CVA, corporate voluntary arrangement, is model after the corresponding provision of the UK, United Kingdom Insolvency Act, in 2000, before the 2016 tu lah. Okay, it is a procedure which allow a company to put up a proposal to its creditor. So the proposal is to the creditors. Sebab bila dia buat arrangement, dia akan affect dia punya debt. Mungkin tempoh bayaran dia dalam mungkin kalau 10 tahun dia jadi mungkin 20 tahun for example. So it depends on the creditors because they would be affected by the voluntary arrangement by a company. Okay, so basic idea is that the company put up a proposal to its creditors for a voluntary arrangement. Yeah. Okay, in this type of option, the board of directors remain in management control of the company. Yeah, so they remain managing the company, but will work with an insolvency practitioner. So yang ni third party lah, orang luar yang akan manage the company together with the board of directors, yeah, to draw up the CVA proposal. Yeah. Okay, the implementation of the proposal is supervised by an independent insolvency practitioner. Ya, the third party tu tadi yang yang boleh kata he is the third party to observe the implementation of the proposal for the benefit of the creditors and the company as well. Yeah. Okay, so the practitioner, the insolvency practitioner will also report to the court on the viability of the proposal. Yeah, whether it's a good proposal, yang tu orang accounting lah yang akan tengok, orang business apa semua tu. Then they know whether certain proposal is viable or not, whether it is at the interest of the company to rehabilitate the company ataupun as well as the creditors. So dua perkara ni penting lah, yeah, for the practitioners to observe. Yeah. Okay, so basic idea is it is a management-driven restructuring process, yeah, of the company itself. Sebab tu yang ada proses tu yang di-involve macam dia kurangkan pekerja, yeah. Dia macam mungkin dia jual certain asset, yeah, untuk cover certain loss, yeah. Okay, so those are part orang business punya cerita lah, yeah. So I'm not really good at those managing the company, kan ada dia punya specialist. Okay, then basic idea is that there is a minimal court involvement, yeah, compared to the other yang judicial management tu. Okay, this should allow the process to be quick and with lower costs. Yeah, so that's another difference as well, yeah, compared to the judicial management order. Yeah. Okay, what companies can apply the CVA? Yeah. So kita tengok apa yang tak dululah kat sini. Section 395 says the CVA cannot be carried out in a public company. Yeah. Yang berhad punya tu, company berhad tu dia tak boleh apply, dia tak boleh guna pakailah the provisionnya. Okay, then a company which is a licensed institution or an operator of a designated payment system regulated under the law enforced by Bank Negara Malaysia. Okay, so bank, financial institution tu semua tak boleh pakai this provision. So maksudnya dia tak boleh rehabilitate using this provision. Okay, and then company which is subject to Capital Market and Services Act. So yang company which is listed, macam public listed company tu tak boleh pakai. So basically company yang subject to Capital Market ni adalah company which is listed in the stock exchange, yeah, public listed company lah. Okay, and then number 4, a company which creates a charge over its property. So sebelum ni adalah banyak orang tanya, so company apa yang boleh pakai, kan? So macam most of the companies tu tak boleh. So most of the companies sebenarnya akan create a charge over its property, kan? So it's macam narrowed down actually the application of the provision. Okay, so macam looking at the provision here, we can say that only private companies yang sendirian berhad tu saja, which has no secured debt, can apply the provision. So macam sangat kecil lah sebenarnya ruang lingkup types of company which may apply ataupun resort to the corporate voluntary arrangement. Yeah. Okay, you got this? Any questions so far? Okay, tak ada soalan.
Yang nombor 4 tu saya kurang jelas.
Okay, so company, Syahmi asked about a company which create a charge over its property. So it's a common practice for business people, macam a company lah. So to secure a loan, yeah, loan daripada bank for example, commonly for a company bila dia nak buat loan, dia akan buat loan dalam jumlah yang besar. So when there is a large amount of loan, the bank commonly will require for a charge macam security for the loan. Okay, so if for example a company charge dia punya property tu to secure a loan, mungkin dia ada satu tanah for example, bangunan for example, so dia boleh charge kan. Banyak juga contoh macam developer of a house, macam housing development. So when they have mungkin that company has macam a piece of land, so dia punya tujuan adalah untuk develop the land into a township. Kan mungkin dia ada macam a piece of land macam mungkin a few hundred of acre for example to become a township. So in such a situation dia boleh take a loan from bank to fund ataupun finance dia punya development project. Okay, then they charge the land to as the security for the loan. Okay, so that is a charge over property. So in section 395, such a company which has a charge over its property. So dia tak kisah banyak mana pun charge tu, tapi dia tak boleh apply the CVA if it has it is suffering from financial distress. Yeah, so do you get this? So any company which has a charge over its property. Okay? Boleh tak ada nampak tak situation tu?
Faham tak?
Okay, that's good. Yeah. Okay, so basic idea adalah yang ni lah, kita boleh kata what company can apply the provision. The companies which are private in nature, private limited company, kan yang sendirian berhad tu, with no secured debt. Secured debt tu yang kat sini, number 4. Debt security over the debt. It's debt tu, so then they can apply for CVA if it is under financial distress. Yeah. Alright. Okay, next we look at the okay, yang ni explanation yang tadi lah. So basic idea is that CVA can only be utilised by a private company, sebab public listed company tadi tak boleh kan. Okay, then where the company has no secure, that it falls under number 4, requirement number 4. Okay, so the situation, there are many critics lah against the new provision because of the narrowed scope of the provision. Yeah? So macam there are calls actually for the provision to be also applicable to the company which has secured debt as well. Yeah? Okay, saya check tadi since March 2018 only 2 companies have applied for CVA. So sebab dia punya narrowed application, sebab jarang kita nak jumpa company yang tak ada security over its debt. Kecuali contoh macam orang yang macam orang kaya, dia ada duit contohnya kan, mungkin tak ada duit, dia buka company, dia mungkin bisnes apa-apa kan, guna duit dia sendiri. So in such a situation dia tak perlu ambil loan, dia cuma gunakan duit dia sendiri for the business. Okay, so yang ni very safe punya company lah. Yeah. Alright, so this is the application of the provision. Okay, so how it works. We talk about the procedure lah ya, to apply ataupun to the process of the CVA. So it is initiated by the directors of the company. Okay, the proposal is presented to the creditors for the agreement of the creditors, approval of the creditors. Yeah, so the proposal includes the nomination of an insolvency practitioner, they call it. Yeah, which in here, in the provision tu dia panggil nominee, dia macam third party. So if you remember, untuk yang kita punya bankruptcy, dia ada juga voluntary arrangement kan. So before a person is to be macam adjudged bankrupt, one of the way to rescue himself tu is by way of application of the voluntary arrangement. So in which he will appoint a nominee, itulah orang ketiga penama ni, to act for him, to rescue macam to make macam dia panggil arrangement ataupun negotiation for the repayment of the debt. Ini sama juga proses dia dekat sini. Yeah. Okay, how the proposal is made tu is under section 395. Kemudian baca, so basically is dia letakkan prosedur dia macam basically the director of the company tu, they work together with the insolvency practitioner to draw up the proposal. Okay, and then the proposal will be filed in the court. Yeah, so and then the creditors will be notified. Okay, and then they call the meeting. Okay, and then the creditors would have to agree. Bukan have to agree. If they agree, yeah, if majority of them, they not 75% of them to agree to the proposal, then it will be it become like macam agreement, yeah, which will be binding to all of the creditors. Yeah. Okay, so that's basic idea of it. Yeah. So what is the effect of the proposal to be filed in court? Yeah. So upon the filing of the document in court, there will be a moratorium, kita panggil. Yeah, a moratorium commence automatically. Moratorium ni macam during yang COVID-19 kan banyak kita dengar tentang moratorium tu kan. Yang mana contoh macam PTPTN dia kata tak payah bayar dalam tempoh 6 bulan. So it's a stop lah. Macam dia punya effect is to stop an action. Yeah, that's what moratorium is. Yeah. So, what is it? Yeah, for the filing of the CBA, there will be no legal proceeding to be taken against the company. So, any creditors could not file any proceeding in court. Yeah. Okay, so the timing tu singkat je sebenarnya 28 days. Yeah. So, but the duration of the moratorium is 28 days. So that means the process must be done within 28 days. Yeah, dah sebulan je, which is very fast actually. For the directors to work to get the creditors to come to the meeting and to get the agreement of the creditors. Yeah. So this allow for time limited, dipanggil macam so biar boleh dia bernafas kejap. Mungkin dia dengar ada creditors, dia dah tak bayar hutang mungkin dah berapa bulan. So dia dengar ada creditors would like to file a legal proceeding against them. So dia boleh resort to this provision in order to stop the legal proceeding. Yeah? So that's the effect. Okay, so during the moratorium, the company could not be wound up. Okay, no judicial manager can be appointed. So yang second situation, second option could not be adopted. And there is no security can be enforced. Macam creditors, dia tak boleh jual dia punya security yang charge tadi, in order to secure the repayment of the debt. Yeah. Okay, and then there is no shares can be transferred. Yeah, so you can check the section 398 to look at the detail of it. Okay, however, a secured creditor may appoint a receiver to deal with the charged property of a company. Yeah, kalau dia cuma boleh appoint je a receiver. Yeah, during the moratorium, tapi dia tak boleh enforce the security lagi. Yeah. Okay, so that is the effect of the moratorium. Okay, and then, so once filing of the proposal, yes?
Madam, saya tak faham yang kenapa secured creditor tu boleh appoint receiver bagai tu, sebab saya fikir tak ada dalam CVA ni. Ini dalam tajuk CVA lagi ke moratorium ni?
Betul, dalam CVA lagi.
Saya fikir dalam CVA bukan tak boleh ada any security dealings ke?
Dia tak boleh secure, dia tak boleh jual security tu. Dia tak boleh enforce the security.
Yalah, tapi bukan apa yang saya faham lah. Tadi Madam terangkan.
No security can be enforced kan. Tapi tiba-tiba ada yang secured creditor may appoint a receiver to deal with the charged property. Okay, that situation yang kat sini ni, okay, nanti kita check kemudian kat sini. So mungkin ada misunderstanding ke? So later, saya take note yang tentang ni. Dan later kita baca section 398 juga. Okay? So this is what I read actually from macam ada several sources. Still the creditors can appoint a receiver, walaupun they cannot be enforced at that particular time. Tapi saya check balik dia punya situation, sebab by right within the 28 days tu dia tak boleh enforce lagi. Okay, so kita check balik that part. Okay, thank you, Wafi. Yeah. Okay, and then next process is to have a meeting. Yeah. So upon the moratorium coming into force, the insolvency practitioner or the nominee itu is to summon a meeting of the creditor, the company and its creditors within 28 days after the filing of the document in court. So the process 28 days tu is actually very fast, which must be done lah. Macam the timing tu is because it affect the interest of the creditors in that situation. So if more time is required for the stakeholders to decide on the proposal, so they can apply for extension for further period not exceeding 60 days with the approval of 75% majority in value of the creditors at the meeting. Yeah, so for example, if they would like to restructure the proposal, they still can apply for extension, but must be with the agreement of the majority of the creditors. Okay. So yang duration dia kat sini lah ya, 28 days up to 60 days. Yeah, okay, that's it. Yeah. Okay, and then during the meeting, yeah, so simple majority is required to approve. That is 75%. I think it's not simple majority lagi dah kan, 75% is quite substantial kan. So it's actually majority. Kalau simple tu biasanya company 51% of the majority. So yang the wording tu sebenarnya adalah yang ni lah 75% of the total value of the creditors present and voting. Yeah. So if it is approved, 75% of them approved, then the CVA will take effect. So they will become macam like an agreement which will bind all of the creditors. Yeah. Okay, however, kalau ada security tu, tapi still the creditors ada right to enforce dia punya security. So sebab yang tu agreement tu comes before. Yeah, okay. So that is macam, sebab tu macam bank kalau large amount of sum tu dia akan require security. Sebab macam mana pun dia punya security tu will, dia punya property which is secured tu will get back to the rights of the creditors, the secured creditors. Okay, so that is the result of the meeting. Kalau contohnya the approval of the creditors could not be achieved, then the proposal would be thwarted lah, maksudnya would be abandoned, so it will not have it will not take effect. In such a situation, the creditors can do anything that they have rights to do, like macam to take legal proceeding, kan, to enforce dia punya charge, yeah. So those things untuk dapatkan balik dia punya debt. Dan another situation is to continue for winding up proceeding. Yeah. Okay, and then who to implement the proposal? I think you can guess. That is the young insolvency practitioner tadi, which is appointed by the meeting itself. Yeah, approved by the creditors as well. Yeah. Okay, so if, for example, the agreement tu tadi yang achieved in the meeting has not been implemented, so then the voluntary arrangement will come to an end. Yeah? So maksudnya dia tamat dekat situ lah. So then all of the person involved would be macam discharged from the liability under the agreement, that is the, ataupun dia punya binding effect of the agreement reached under the meeting. Okay, so that is how it works. Yeah? So it's a macam straightforward process. So dia punya filing of the proposal tu is in court, tapi the rest of the process is observed by the practitioner, insolvency practitioner appointed under this. Yeah? So yang ni kita punya summary lah, yeah, daripada proposal to be filed in court. Okay, and then moratorium take effect, yeah, upon the filing of the proposal. So within 28 days, meeting must be conducted involving the company and the creditors. So if it is agreed, 75% agreed, of the creditors agreed, then it will be binding over all of the creditors. So then they implement lah. Contohnya kalau dia kata macam mungkin certain debt to be repaid macam in longer duration of time, so then it will take effect. Yeah, so dia adalah proses dokumen dibuat oleh insolvency practitioner later on. Okay, so that is about CVA. Yeah, so any question? So saya check. chat, ada chat apa-apa soalan? Tak ada soalan? Okay, boleh?
Madam, saya ada soalan.
Siapa cakap? Wafi, okay?
CVA ni tadi saya ada perasan satu lagi, mana tadi? Dia akan enforce kalau dah ada simple majority kan?
Dia 75%. So it's not simple. I think we should delete that. Dia bukan 75, ya. So betul kan? Ya, nanti.
Okay, lepas tu
It is 75%. The word is 75%.
lepas tu madam, kalau ada yang tak setuju tu dia boleh challenge ke benda ni?
Okay, kalau later lepas dia dapat ni, yang ni tak ada provision untuk challenge sebab dia dah over meeting approval by the court. Unless kalau dia kata dia punya meeting tu tak valid, contohnya mungkin ada creditors yang is not notified, then you can challenge.
Oh, I see.
So dia masih juga in any process actually, if you can find out any macam failure to observe the procedure. So contoh macam notice must be given to the creditors, semua creditors. But then the creditors did not, certain creditors mungkin yang penting, yang mungkin ada creditors kata dia tak pernah terima pun notice tu. So in such a situation, they can challenge. They can go to the court for failure to observe the procedure.
Oh, so dia more kepada procedure lah kalau nak challenge benda ni juga kan?
Betul. It is the procedure. The procedure must be observed. So mungkin tentang macam qualification of the nominee tu, dia ada specified nominee, that is the yang insolvency practitioner tu kan. Contohnya dia adalah not a qualified person kan, dia ada rules regulation lain lah untuk for a person to be a qualified insolvency practitioner ataupun specialist dia panggil. So mungkin dia boleh challenge part tu. So being a lawyer, macam defense lawyers, macam mungkin yang Cik Azmi bagi tahu itu kan, bila kita defense, we are on the part of the defense lawyers, mungkin any creditors, for example, yang nak challenge anything, you need to see all of the macam provision under the law and see if there is any provision of the law which is not observed. Yang bukan formality punya. Contoh yang macam bankruptcy kan. If for example the formality does not affect macam the rights of any person, macam mungkin dia terlupa nak tulis apa-apa contohnya dalam dia punya affidavit tu, mungkin jurat dia tertinggal contohnya, tapi ada sign contohnya, tapi ada satu ayat dalam jurat tu dia tertinggal contohnya. So tapi perkara tu not affect the macam the rights of the people. Okay, the affidavit would remain valid. So dia panggil irregularity which does not result in miscarriage of justice, dia panggil. So in such a situation, mahkamah biasanya akan ignore kan kalau kita nak challenge. So on the part of the lawyer, dia kena tengok lah sama ada all of the procedures tu are observed. Okay.
Lepas tu madam, kalau tadi kan ada 402 cakap dia akan end jika tak enforce kan? Maknanya kalau once challenge dah succeed, tak boleh buat lagi dah.
Betul. Kalau it has been kalau
sekali je
sekali apa dia? Sekali orang
proposal.
Proposal tu proposal tu boleh buat, tapi dia boleh buat sekali. There is no provision which macam macam hinder any other macam repeat lah, contohnya macam mahkamah kata this is not valid kan, so they can always macam resort to the provision again if they think it is necessary. Dia boleh buat lagi lah maksudnya, tapi dalam situation yang company which is under financial distress, dia punya cost of the CVA ni pun dia ada cost juga nak bayar dekat dia punya practitioner tu tadi, specialist dia tu tadi pun is quite some amount jugalah. So dia akan consider all those aspect lah. Contohnya kalau dia abandon contohnya certain arrangement, so there must be reason lah for them to abandon. Mungkin dia ada someone else inject money to the company contohnya. So mungkin the business is getting better again for example. So they feel that the arrangement is no longer macam effective, for example, so they can always not enforce the arrangement. Yeah. So I think that always depend on the situation. Saya rasa macam sekarang kan, we don't know how long the effect of the pandemic will affect the economy. So ada yang kata sampai 5 tahun, ada yang kata setahun, tapi there are companies which try macam company yang medical instruments contohnya, so they try very well sebab their products are in demand kan. So mungkin the way the business is important, the situation is also important to affect the economic health of the company. Yeah?
I see. So maknanya kalau benda tu dah challenge pun dan berjaya, court still akan reconsider lah.
Kalau is challenged by the creditor tadi, any other person contohnya?
Kalau macam saya tanya, creditor lah. Yang tak setuju tu. Yang minority tu lah. Kan katakanlah ada benda yang prosedur yang tak ikut lah, lepas tu akan effect substantial justice. Itulah macam Madam cakap, mungkin court akan pertimbangkan tu, maknanya pertimbangkan kalau dia nak buat balik tu sebab costly apa semualah. So kalau court
kalau nak repeat balik prosedur tu, court kata benda tu tak sah contohnya, dia nak repeat the procedure. Macam tu ke soalannya? I don't think there is any hindrance to that. So they can kalau contohnya macam ada prosedur yang tak cukup contohnya, so they can always resort to that arrangement again. Ya. Tapi saya rasa dia kena tengok juga situation, contohnya orang creditors yang mungkin tak datang meeting tu contohnya, mungkin dia pegang majority of the debt tu kan, mungkin dia je pegang mungkin 40% contohnya. So in such situation company tu memang tak boleh masuk lagi arrangement macam ni. So situation tu penting juga for the company to strategize.
Oh, I see. Tapi setakat ni macam Madam cakap, dia tak ada provision yang cakap tak boleh buat 2 kali.
Tak ada. I don't think any. If you can check again. So I don't see any. Ada tak? Kalau later if anyone tu boleh bagi tahu jugalah. Sebab this is a new provision under the law, not tested in court, yet to be tested actually, and even only 2 companies so far dalam as reported lah ya, yang use this provision. Yeah?
Okay. Thank you, Madam.
Okay. Alright, thank you so much Wafi for the question. Okay, so boleh tak kita teruskan untuk yang satu lagi judicial management order tu? Boleh? So ke penat nak stop for a while? Wafi boleh? Filza, okey tak? Filza ada tak hari ni? Okey, boleh ya? Okey. Kita tengok yang satu lagi, judicial management. The 2 slides are in your goals. Yeah, you can check later for your study juga kan. Okay, so we look at the second one, that is judicial management. When we use the word judicial is used here, so that means the court has greater say compared to CVA just now. CVA tadi the company yang ada greater say, the company remain to manage the company itself, dia punya board of directors ya. Okay, so basic idea kalau yang tadi CBA is model after the UK provision, yang ni Singapore punya provision. Yeah, so dalam proses drafting of the laws tu dia tengoklah several tu, mana yang elok dia rasa tu dia ambil lah. Yeah. Okay, so it provides another option to rehabilitate a financially distressed company. This essentially places the management of a company into the hands of the court-appointed restructuring specialist. Yang tadi, yang CVA tadi tu, dia propose, company tu yang propose dia punya practitioner. Tapi yang ni court yang appointed. Yeah? Okay, it allows the company or creditors. Yeah, so yang CVA tadi company saja yang start kan. Okay, sekarang untuk JMO ni both parties, the companies and the creditors can apply for an order to place the management of a company in the hands of a qualified insolvency practitioner. Dekat sini dipanggil judicial manager. Yeah, that is a person who is appointed by the court to manage the company. Yeah. So this includes the company's affairs, business and property of the company. Yeah, so dia lebih stringent lah dekat sini ya. So the duration of the order in force is for 6 months with the possibility of a further 6 months. So yang tadi tu berapa? CVA, remember? Do you remember what is it?
28 up to
That's right.
60 days.
That's right. Okay. So yang ni lebih panjang lah masa dia ya untuk judicial management. Okay, so what company can apply? So dalam undang-undang dia cuma kata non-application. What company which cannot apply for the JMO? Ya, dia kata two kinds of companies which cannot apply. That is the licensed institution under the CBM, ya, Central Bank of Malaysia. That is the bank and the financial institution. Yeah, could not apply the judicial management order. Okay, and then second one is the company which is subject to the Capital Markets and Services Act. Yang ni sama dengan yang CVA just now. Okay, therefore this appears to exclude public listed companies from applying for judicial management. So yang dekat sini dia lebih besar lah. So contoh macam Sendirian Berhad punya company. Apa dia lagi yang even company which has macam charge over its property can apply for JMO. Yeah. Okay. So who is to make the application? It's the company itself by way through its directors or the creditors. Yeah, either together or separately. Sama ada seorang-seorang creditor ataupun they band together, yeah, to apply for judicial management. Kalau ada 10 creditors for example, so then they can band together to initiate the process. Yeah. Okay, and then what are the consideration for the application for GM on the part of the company, yeah, ataupun on the part of the creditors as well. So they so this condition must be satisfied to the court. That is, yeah, an application for an order that the company should be placed under judicial management and for appointment of judicial manager may be made to the court if it is considered that the company is or will be unable to pay its debt. Yeah, so mungkin dah 2 bulan tak bayar ke, contohnya upon notice dia tak bayar hutang for example. Yeah, so as to the definition as to the inability to pay its debt tu nanti kita tengok masa winding up, dia sama saja. Yeah. Okay, so saya rasa macam dah belajar juga dalam company law juga kan, sikit kan. Tapi dalam untuk winding up nanti kita tengok lagi how does the court define ataupun what is the definition of inability to pay its debt tu under the Companies Act. Okay, and then how does the court explain this? Yeah? Okay, that is the first condition. Okay, the second one is there is a reasonable probability of rehabilitating the company. Yeah, so it is they see the possibility that the company may be revived again. Yeah, ataupun mungkin dia bukan again lah, maybe revived, mungkin dia nampak macam dia punya financial situation is really bad, they are not able to pay debt, tapi they are still macam situation, mungkin certain asset of the company which may allow them to revive the company, yeah, or of preserving all or part of its business as a going concern. Yeah, it is important for the people within the business, the shareholders, dia punya creditors, yeah, so it is important for the interest of these people as well, yeah, which would be better than winding up. Sebab bila winding up semua pun habis kan, all of the pekerja semua sekali memang dah kena kena berhenti, all of the properties of the business. So some of the business tu are too big, involving so large interest of people. So these are the situation which would be macam taken into consideration in order to apply for JM. Yeah, so when an application is made to the court, they need to show this. Yeah. Contohnya kalau is by the creditors of the company, dalam affidavit dia tu nanti dia kena tunjukkan yang the company tu is unable to pay its debt at present. Yeah? Ataupun mungkin in future tu mungkin dia kata dia boleh bayar hutang dia dalam tempoh 3 bulan je. So later than that, it's difficult to pay, to observe the repayment of the debt. So dia kena tunjukkan dalam affidavit dia lah. Yeah? And then second one, dia kena tunjukkan that there is a probability, mungkin dia believe that the business will be going to be doing better again. They are how they are to revive the company. For example, mungkin dia ada restructure certain company business in order to rehabilitate the company. So these are the two situations that must be considered before application is made to the court. Okay, boleh. Okay, yang ni on the part of the company yang apply ataupun the creditors yang apply. Okay, on the part of the court tu nanti kita tengok later. Yeah. So yang ni the procedure for the application. Yeah. So for this, there must be the application tu must be made to the court, and it must be advertised. Yeah, advertised so that public knows the position of the company. So contohnya bila ada situation yang macam ni, so it's would be advertised in the news, and the news also will pick up the situation as well. Okay, and then for example, if the creditor who make the application, so the notice of application must also be given to the company. Yeah. Okay, and then another person which must be made known is the registrar, registrar of the company. Yang ni lah proses dia dekat sini. Dia punya further process, detail process tu dalam rules. Okay, and then section 410 tu talk about the effect of the application. So once the application is filed in the court, so effect dia sama dengan CBA tu tadi. That is the moratorium. Yeah. So dia kata during the period beginning with the making of an order of application of GMO until its disposal, maksudnya disposal tu sampai the court decide for it. So there is no resolution be passed, resolution for the winding up of the company ataupun order, winding up order tu lah. Yeah, that is through the compulsory winding up to be made for the company. Yeah. Okay, so second one, no step shall be taken to enforce any charge or security of the company. So ada senarai dia lagi yang related to the charge and security juga. Okay, and then the third one, there is no proceeding and no execution or other legal process shall be commenced except with leave of court. Yeah, so still boleh commence but must be with the leave of the court. Yeah. So that is the effect of the moratorium. So more or less similar dengan yang situation tadi, yang CBA tadi, tapi tak ada bab charge tu sebab company yang dah secured ada security over the debt tu dia tak boleh apply untuk CBA tadi kan. So tak adalah yang tu. Okay, so boleh. Kita tengok case satu, ada dua case so far untuk JMO. Yeah, satu case yang CIMB, Islamic Bank and Welcome Communication. So basic idea is dekat sini. Dia kata, Court of Appeal kata, once the judicial management application is dismissed, kalau court tolak permintaan tu, application tu, so there cannot be a grant of any stay order. So maksudnya, if for example the creditors apply for JMO, okay, but the court dismiss the order, okay, so then the creditor tu cannot apply for stay of the order for the dismissal of the judicial management application. Yeah. Okay. Boleh kat sini? Yang ni case yang decision is quite recent. Yeah. Untuk yang interpretation of section 410 here. Okay, boleh? Yeah. So that is the effect of dismissal of the judicial management application. Yeah. So related to the consideration of the company to ataupun creditor to apply for JMO, the court also should be macam relate to the same consideration as well when they make JMO. Yeah, so the first one is that dia punya consideration lah dekat sini ya. So the court is satisfied that the company is or will be unable to pay its debt. Okay, that is the first. Okay, and then the second, the court consider that the making of the order would be likely to achieve one or more of the following purposes. Yeah? So the first one is the survival of the company. Yang proses yang rehabilitate the company just now. Okay, the second one, the approval or an arrangement between the company and its creditors under section 336. Yeah, so contohnya, for example, before the JMO has been taken, so they have made some arrangement. before that between the company and its creditors. Dia ada macam satu perjanjian lah. Arrangement tu sort of macam rearrange dia punya repayment of debt, rearrange dia punya value of the shares, class of shares. So those aspect of macam asset ataupun the value of the company itself. Kalau ada yang ni approval kat sini, okay, and then the JMO will be able to achieve the implementation of the arrangement tu. Okay, that is the second one. Okay, and a more ataupun kat sini a more advantageous realization of the company's asset than on a winding up. So it is felt that the company's asset would be better managed through JMO rather than winding up. Then the court ni make the JMO. Yeah. Okay, if you can see here, this relate to yang dekat consideration on the part of the company or creditors to apply for JM as well. Sama benda dia. So maksudnya on the part of the company, dia pun kena consider masa nak apply for JMO, this situation. And on the part of the court, they, in order to give the order, the court will also have to satisfy itself that these conditions are there. Yeah. Okay, boleh follow? Okay, so this is under section 405. Yeah.
Madam,
Yeah.
apa
Okay.
beza consideration tadi, consideration of court dengan consideration that needed to be taken by the court dengan taken by the company and the creditors? Apa beza dia? Macam sama je ke?
Ya, sama. Betul, sama kecuali yang dekat sini. Saya ambil kat sini. Dia sama je Wafi kalau letak next to here dekat sini kan. Dia sebenarnya sama je. So macam both parties, jadi kecil sangatlah ya. Okay. Yang dekat sini ni adalah on the part of the creditors dengan company yang nak initiate the application for JMO. So tengok kat sini, A itu company will be unable to pay its debt. So dalam affidavit dia kena tunjukkan bahawa they having difficulty lah to pay its debt. And the second one ada probability to rehabilitate the company. So that is on the part of the creditor ataupun company tu proof. Yeah. Okay, and then the court bila tengok tu kan sama, betul tak? Dia survival of the satu yang A tu tadi will be unable to pay its debt, relate to here. And then second one tu survival of the company. Tapi dia tambah kat sini ada situation yang dekat sini yang berbeza daripada yang dekat sini. Tapi I believe when I look at this, dia kata kat sini otherwise serving the interest of creditors better than a winding up. So yang kat situ adalah explanation kat sini, advantageous realization of the company's asset than on a winding up. Kan? So it's just explain this in detail dekat sini, dua perkara kat sini.
Oh.
Tapi both parties macam on the part of the applicant yang buat application tu and the court will look at the same thing, the same page lah maksudnya. Betul tak? Sama, dia ada relation between the two.
So maknanya kalau court ni dia dia punya consideration tu lagi in details sedikit lah.
Macam in detail tu sebenarnya dia explain further this B kat sini. Yang kat sini dia explain situation in which macam it would be in the interest of the company contohnya dan creditors juga kalau to realize the company's asset through then a winding up.
Oh, I see.
So saya rasa is more explanation rather than two different things here. So yang kat sini the law tu is made into detail, they explain yang dekat sini.
Oh, I see.
So yang kat sini or preserving all or part of the business as a going concern or otherwise serving the interest of creditors better than in a winding up. Yeah. So kat sini a more advantageous realization of the company's asset than on a winding up. So sama je lah, ayat je macam lain sikit kan. Betul tak? Alright.
Betul.
Okay.
Thank you, madam.
No problem. That's good for you to ask. Yeah? Okay, so kita tengok tadi power of the court to make a JMO. So dia kena satisfy all of the condition before they can make an order. Okay, so what is the order actually? Yeah, so the GMO shall direct that during the period in which the order is in force, the affairs, business and property of the company shall be managed by a judicial manager appointed by the court. So maksudnya before this, the management of the company is by the board of the director, but now is by the judicial manager, a third party lah, which is appointed by the court. Yeah? Okay, so that's dia macam mungkin the creditors disbelief in the ability, for example, of the directors to deal with the company, to manage the company. So then maybe judicial manager can do better to rehabilitate the company. Yeah. Okay, so what is the implication of a judicial management order? So the first one, the board of directors cease to function. Yeah. So semua judicial manager lah yang buat. And then there is an automatic moratorium on any transfer of shares, legal suit and enforcement action against the company. So within the process, within the enforcement of the order tu, so no other creditors tu can bring legal action against the company. Okay. And then on the part of the secured creditor, no step can be taken to enforce any charge or security. So macam dia kena deal dengan GM tu lah, judicial manager tu, untuk deal with the company sebab dia nak save the company dulu kan. So mungkin kalau dia boleh bayar hutang, dia boleh negotiate dengan creditors tu first, before the creditors can enforce any charge. So within the duration of the order. Okay, and then any receiver and manager already appointed. So there are situations in which the creditor can appoint receiver and manager of a company. So in such a situation, they will be required to vacate the office. So this is under the observation ataupun the supervision of a judicial manager. So that is the effect of the judicial management order. So maksudnya dia pass dia punya management to another person, that is judicial manager. Okay, so okay, yang ni siapa yang boleh jadi judicial manager lah ya. So judicial manager tu must be a person who is qualified as a insolvency practitioner dipanggil. So biasanya adalah accountant ataupun auditor. Dia adalah dia punya regulation lah untuk yang tu ya. Okay, and then so once the judicial manager has been appointed through the order, judicial management order just now, so is the judicial manager to work, that is within the 60 days duration tu tadi. So that is, dia akan buat proposal for restructuring. Mungkin dia lah yang akan study the company, dia punya account, dia punya asset, dia punya debt kan. So and then dia punya business, how to restructure the company. Okay, and then dia akan buat proposal lah. Mungkin ada proposal dia kata mungkin kita kena buang kerja separuh, contohnya pekerja. Mungkin kita kena jual certain asset for example. Okay, so those are under the proposal by the judicial manager. So and then the judicial manager tu dia tak bolehlah buat keputusan seorang-seorang sebab yang would be affected adalah creditors tu nanti harta dia macam dia punya debt, dia punya loan apa semua tak dibayar contohnya kan. So in such a situation there must be a meeting. Judicial manager dia cuma structure the proposal ataupun macam draw up the proposal tu apa yang perlu buat, dia rasa perlu buat lah sebab yang ni professional people yang akan study the company semua kan. Okay, and then dia akan propose, okay, and then dia akan present to the creditors. So if the creditors agree, 75% of the value of the creditors claim to agree, so yang tu dia ikut value of the debt tu. Contohnya kalau seorang je creditors dia bagi loan mungkin 50% of the loan of the company tu belong to one person. So kalau dia setuju lah. Okay, so it depends on the how many values of the debt owed to the by the company to the creditors. Okay, once approved by the required majority, the proposal binds all creditors of the company, whether or not they had voted in favour of the proposal. Okay, so sama kan dia punya proses tu tadi. Cuma proses yang tadi tu dia meeting sama-sama company dan creditor saja dalam CBA. Tapi kalau untuk judicial manager tu dia appointed by the court, mahkamah perintahkan appoint the judicial manager. The judicial manager yang propose, yang study the company, investigate the company and then make the proposal for the restructuring. Okay, and then present to the creditors. Okay, and then if agreed, then bind all of the creditors. Yeah. Okay, so yang kat sini kalau dekat ni lah ya, when the court will dismiss the application. Yeah. So bila contohnya a receiver, two situation, that is receiver and manager has been or will be appointed. Okay, and then the making of the order is opposed by a secured creditors. Yeah, strong position lah ya untuk secured creditors, dia boleh oppose the making of the order. Yeah. Sebab the JMO will affect the position of the secured creditors to realize the security within the duration of the process. Okay, so yang ni kecil sangat saya letak ya. The role, saya dah cakap tadi tentang the role of judicial manager, that is to investigate the company, kan, to restructure the proposal, to restructure ataupun to draw up the proposal to restructure the company, to get the approval. Okay, so that's basic idea lah of the judicial committee, judicial manager. Okay, and then these are the situation when the judicial management order can be discharged ataupun can be set aside. Maksudnya mahkamah dah bagi perintah. Okay, so mungkin ada creditors yang tak setuju, so they can file the application to set aside the order. Yeah. So situation dia kat sini lah. Yeah. Contoh, creditors do not approve the judicial manager's proposal. Yeah, so mungkin dia tak sampai yang 75% of the creditors agree to that proposal, then the order will stop. Yeah. Okay, and then the purpose of the judicial management order has been achieved. Yeah. Mungkin dah semua orang mungkin they got the majority agreement to the proposal. Okay, and then they has managed to revive the company. Yeah. Okay, then the purpose of judicial management is incapable of achievement. Mungkin they found that the company could no longer be revived. So in such a situation, then the judicial management order can be set aside. Yeah. Okay, and then there is unfair prejudice. Yang ni besarlah situation dia. Mungkin ada yang kata dia tak tahu pun, dia tak dapat notice, for example, the procedure has not been observed, for example. So yang ni besar, boleh kata blanket provision which may allow for the setting aside of the order. Okay. Dalam kes yang ni, Litman Development Sdn Bhd, Mahkamah kata there is a glaring lack of a provision in the Companies Act 2016 and the rules for the setting aside of the judicial management order. Yeah. So maksudnya dia tak ada regulation pun yang kata how to set aside the judicial management order. Yeah. So yang ni mahkamah komen sajalah ya. So in situation yang macam ni on the part of the lawyers, selalunya dia akan get back to the rules of court 2012 ya. Walaupun dia tak ada specific procedure. So proses dia selalu sama, notice of application file together with the affidavit of support ya, walaupun tak ada mention dalam rules ya. So mahkamah bagi komen sajalah ya kat sini. Sebab dekat provision for UK tu dia kata it expressly allow for the setting aside of an administration order. Yeah. Okay, so mungkin lack of provision in Malaysia, but I think itulah macam yang saya kata tadi, rules of court is a general provision which would be applicable. Dalam rules 2018 pun kata kalau tak ada absence of specific provision in the rules, then the rules of court 2012 will be applicable. Yeah. Okay, yang ni saya minta baca kes ni. Yeah. Basically, this is the case on setting aside of JMO by creditors. Yeah. Ni kes yang apart from yang welcome tadi tu, CIMB welcome, yeah, this is another case in which the court discuss JMO. Yeah, sebab baru lagi kan 2017 enforced kan, so there is no other cases untuk discussion about the JMO, yeah, application of JMO. Okay, so any question about JMO, judicial management? Wafi, okay, Filza, siapa lagi? Farhana, Ain.
Question.
Mm-hmm.
Untuk ni company voluntary agreement, judicial, semua ada tu
Imran,
lagi
suara
saya-
putus-putus. Boleh ulang soalan tak? Suara putus-putus, Imran.
Saya nak tanya,
Mhm. So Imran mungkin boleh chat kot. Okey, Imran dah tak ada dah. Hilang dah ke? Hilang dari radar nampaknya. So yang lain boleh dengan saya ke? Line saya yang tak okey?
Boleh doktor, boleh dengar suara
Boleh
doktor.
dengar. Okey, very good. Thank you.
Imran je.
Imran je. Okey, Imran boleh chat soalan juga? Ya, boleh. Okey, tak apa, kita tunggu. So, ada soalan lain tak? Ada sesiapa? Kausar?
Madam,
Ya.
saya nak
Wafi.
tanya pasal kes CIMB tadi dengan welcome tu. Saya kurang jelas kes tu ni bincang pasal apa, kalau
Yes.
application of apa?
Dia sebenarnya cakap tentang welcome tu tadi, yang mana judicial manager kan. Dia cuma cakap tentang dia cuma explain je this is an application. Okay, so this is an application for judicial management. Okay, and then the court dismiss the application. Okay, so and then the applicants tu, once the order has been the application for the order tu has been dismissed, maksudnya mahkamah tolak. So and then the applicants tu apply, masukkan permohonan baru untuk stay the order. Maksudnya kalau saya tak ingat company tu yang apply ke the creditors yang apply, bank tu yang apply. Yes, the bank, that is the creditors yang apply for JMO. So and then the court dismiss the application. So bila the court dismiss, the bank tu, the creditors tu apply for stay of the order. Stay of the order tu maksudnya tujuan dia untuk dia nak continue the moratorium effect of the application. Remember bila kita filekan application to for JMO, the moratorium takes into place. Yeah. Okay, so kalau grant of okay, so in such a situation mahkamah kata tak boleh stay dah. There is no situation to stay the order for the dismissal of the application. So stay ni cuma pakai untuk stay of proceeding dan stay of execution of judgment. Stay of the order ni sebenarnya macam saya tak aware of it. Dan mahkamah kata tak ada grant for any stay order. Ya? Itu saja sebenarnya dekat situ. Dia cuma explain further tentang kalau ada application of JMO. So nanti saya kata saya masuk dalam, saya ada simpan kes tu. Nanti kita baca kes tu, to see what is it. It talks about whether the court may allow for stay of the order by the court.
Oh, I see.
Okay, so nanti saya letak dalam goal, it might be a difficulty for you to macam to find the case. Saya ada simpan case tu. Ya. Kat mana saya punya ni? Okay. So nanti saya tambah case tu dekat sini so that for you to read the case together with yang lead mon tu tadi. Ya. Okay. Boleh?
Okay, madam. Thank you.
Okay, thank you. Okay, Imran tanya soalan. Imran kata, tak ada soalan. Connection problem you can always ask, ataupun mungkin nanti boleh tanya juga dalam WhatsApp ke, dalam goals ke. Ya, ada forum tadi saya letakkan. Okay, Imran kata whether all the procedures are stated in Companies Act or in latest 2018. Okay, basic procedure dia dalam Companies Act yang saya letak tadi, provision dia. Okay, dia punya detail dalam 2018 rules for the CRM, the rules for the corporate rescue mechanism 2018. So dia to be read together. Okay, so saya nak minta baca dua-dua tu for the purpose of your tutorial this week. Untuk buat nanti ada dia punya instruction saya dah letak dekat situ. Okay. So that is for you to macam to understand that better. Yeah. Okay. So ada satu je slide lagi sebenarnya dekat sini untuk judicial management tadi tu kan. Last sekali, remember tadi saya letak 3 kan. There are 3 option to revive ataupun to rehabilitate a company ataupun to avoid from winding up proceeding. That is, the first one is the corporate corporate voluntary arrangement CVA. Second one is the judicial management. Okay, the third one here is yang ni, the scheme of arrangement. Yeah, so this is applicable to all types of companies. Yeah. Scheme of arrangement ni dah lama sebenarnya ada dalam Companies Act since 1965. Yeah, so basic idea is that it is an application to the court by the company, yeah, for the court order. Yeah, order dia adalah meeting to be held on compromise or arrangement with creditors and members of the company. Yeah. So maksudnya still dia pergi ke mahkamah, yeah, tapi it's the meeting tu is macam statutory under the court order. So it's for rearrangement ataupun restructuring of the company. So this is commonly done by the company in order to restructure its debt. Yeah. So the aim dia sama, that is it's for arrangement or compromise to be agreed by majority of 75% creditors or members or class of members present and voting and approved by court order. So dia bukan proses dekat company tu sahaja tapi it involve court order. Yeah, that is another option provided by the law for the companies to rehabilitate. Yeah. Cuma beza dengan CVA dan juga JMO adalah dia tak ada moratorium effect. Macam yang keadaan dekat JMO dengan CVA lah. Yeah, so anyone contoh macam creditors yang macam dia rasa dia punya rights will be affected, so dia tak mau involve dengan arrangement yang macam tu, so they can always start legal proceeding against the company. Yeah. So that is the difference. So I think so the law is improved, yeah, because by way of the 2 option here, that is yang applicable to the 2 companies lah, the types of companies applicable, in order to allow for a space, yeah, for them to be revived. Yeah. So therefore what I can see is that the 2 option provided by the law is to to add to the existing provision, that is scheme of arrangement. Yeah. Okay. So itu yang ketiga. Yang ketiga ataupun ikutlah yang that is one of it. Yeah? Which is dia punya orang kata tak strong lah provision ni. Yeah. Untuk scheme of arrangement here. Okay, so these are the 3 options for the company to resort to ataupun for the creditors to resort to in order to rehabilitate the company when they are facing with financial distress. So I think this is much macam relevant juga dalam situation the current situation in which there are so many companies facing with the difficulties, yeah, due to the situation here. Yeah. Okay. So yang ni references saya rasa yang updated ni adalah yang dekat sini lah, ya. Lee Shih ni lawyers yang an expert in the insolvency practice, dia macam insolvency and macam liquidation of the company as well. Yeah. So dia banyak tulis lah tentang tu. It's good to read these references because I think dia punya explanation tu is easier. Ya, sebab textbook tak ada lagi lah bab ni, ya. Banyak textbook tak ada macam, sebab kalau ada textbook yang cerita pun dia banyak dekat provision saja. So it's good for you to read materials dalam website yang written by the experts in the area. Ya. Okay. So we finish the topic. Yeah. So for the purpose of the tutorial this week, yeah, so I would like you to discuss mungkin dalam 1 jam for the tutorial tu. So you discuss the differences between the 3 mechanism provided by the law. Yeah. So discuss in a group of 4 to 5 the differences between the 3 options. Ya, draw a table or a chart or infographic, tak kisahlah nak guna tangan ke, nak guna komputer ke, nak guna PowerPoint ke, showing the similarities and differences. So I think when you look through macam kita macam bird view lah, bila kita tengok over those three tu, kita nampak lah the differences. So I would like you to upload those in the forum here. Saya tambah ke forum ni. Saya kena tambah dekat sini lah. So you upload your your table ataupun chart apa dia tu yang tunjukkan differences between the three, so that would be part of your tutorial. Okay, boleh?
Boleh.
Okay. Siapa cakap? Saya tak nampak, tak happy kat sini. Siapa cakap? Boleh. Okay, Alhamdulillah. Okay, oh I see, we must refer both statutes. Yes, because rules tu dia provide detailed regulation, remember? On the procedures. Yang act tu dia provide general provision. Kalau yang Imran tanya tu, we must refer both statutes. So basically no compulsion to follow, but it provides option. That's right. It's not a compulsion under the law. You can, the company can choose to resort to that to avoid winding up. So it is hope that the winding up process tu is the last resort. Sebab winding up dia akan end up with the cease of the company. Macam company tu matilah at the end kan. The company will die at the end. So it will affect so many people within the company. Pekerja dia semua habis lah. Kan dia punya director, asset tu semua kena guna bayar hutang lah. And then at the end, balance asset tu akan patah balik pada members if any. Tapi if there is any hope to revive a company, so it's good for the company to resort to the mechanism provided by the law. Sebab bukan senang nak incorporate company kan, nak tu orang kata nak hidupkan satu company pun cost dia mahal kan. So macam kalau kita boleh macam selamatkan company tu dulu from being wound up, then it's better for the company to resort to this. Okay. Okay, that's it for today. So nanti saya akan sediakan macam poll lah untuk siapa vote for which yang mana yang paling yang bagus, macam you feel it reflect the distinction between the three CRM. So they will be present for the winner of the the winner of the macam infographic ke chart ke. Okay, dan saya tak kisah di dalam bentuk apa, tapi saya nak tengok dia macam dia punya substance tu, differences tu, yang tu penting. Differences in term, you can look at in term of what company can apply, the duration, the dia punya procedure. So we'll see that actually helps for you for the preparation of your examination. Okay, alright. So
Madam, saya nak tanya sikit je lagi.
Sure.
Pasal consideration tu sebenarnya saya faham, cuma takut apa yang saya faham tu salah. Apa yang saya faham setakat ni dia punya consideration tu lebih kurang je. Betul tak?
Betul.
Cuma yang madam cakap dia lagi detail dekat court. Yang saya tak faham kat situ je, sikit je.
Kita patah balik dekat tadi tu.
Dekat power of court for JMO dengan application.
Okay, saya besarkan yang dekat sini.
Yang kat situ tu saya tak faham.
Yang tu kan.
Apa yang nampak lain dekat situ tu. Sebab takut macam
tak boleh besar. Okay, dia sama je Wafi actually. Kalau kita boleh letak dia dalam sebelah-sebelah. Okay, this is one way untuk tengok beza juga kan. Contoh, kalau yang kat sini, dia kata dia punya consideration adalah dua perkara ni. That this is on the part of the director.
Okay.
Director ataupun creditors lah. Dua perkara. Yang kat sini pula adalah the court is satisfied. Yang ni yang kedua tadi kan. Okay. Okay. Yang ni this is on the part of the court.
Oh.
Kan. Okay, satu yang dekat sini. Satu, the company on the part of the director ataupun the creditors to file the JMO, dia kena tunjuk kepada mahkamah dalam application dia. Dia kena tunjuk dekat mahkamah yang the company is or will be unable to pay its debt. So dia kena tunjukkanlah macam dia kata notice of demand contohnya telah diberikan kepada company tu, company tak bayar balik. So unable to pay its debt tu is one of the situation dia sama macam bankruptcy notice tu, dia bagi bankruptcy notice tapi dalam company adalah dia bagi notice of demand. So bila dia tak bayar, one of the circumstances situation to show that the company is unable to pay its debt bila diminta dia tak bayar. So notice of demand given dia tak bayar. So that is one of the situation. Salah satu saja tau. Okay, and then on the part of the court sama juga. Mahkamah dia akan tengoklah proof sama ada company tu is unable to pay its debt. So dekat sini dia kata the company is unable to pay its debt ataupun will be unable to pay its debt. Kan? So dia prospektif. Mungkin masa ni dia bayar lagi hutang dia. Tapi contoh kalau macam company tu sendiri, director of the company tu yang filekan JMO, so dia kata dia dalam aset dia sekarang ada berapa dan dalam contoh dalam 3 bulan ataupun tahun depan tu dia memang dah tak boleh nak pay that. Okay, so yang tu prospektif lah, akan kan, will be kat sini.
See.
Okay. So yang ni sama exactly, betul tak?
Sama-sama.
Okay. So yang the second one kat sini, dia kata untuk on the part of the director ataupun the company, there is a reasonable probability of rehabilitating the company. Dia ada possibility dia boleh rehabilitate the company. Ataupun kedua kat sini, dia kata it is important, preserving the business tu is important. Yang ni kat sini, dia kata preserving all or part of his business as a going concern. So, dia kata macam contoh ada certain company tu is important to keep the company. Contohnya macam yang basic service of the company macam TMB contohnya. So, kalau dia going down, dia punya difficulty macam is difficult lah kan that situation. Tapi dia basic service yang mana kita mesti preserve dia. So, that could be one of the example. Okay, and then the third situation kan dekat sini, otherwise serving the interest of the creditors better than in a winding up. Yang ni dia concern dia adalah creditors. Creditors tu yang main peranan besar lah, macam dia punya interest of the creditors kat sini. So dia kata if through JMO tu will distribute, macam dia akan buat arrangement of the repayment to the creditors as well. Sebab kalau winding up, remember kalau sama macam bankruptcy juga, dia punya priority of debt tu creditors tu hujung sekali, betul tak? Betul tak? Kalau yang macam ni through JMO ni, so dia akan perkara-perkara lain yang ke atas macam tax apa semua tu, benda tu dia tak kacau proses rearrangement of the company ni. Tapi bila once the company is wound up, semua priority of debt tu creditors hujung sekali. Mana creditors yang unsecured creditors tu silap-silap dia tak dapat bayar pun hutang dia. Okay. So in such situation, macam mungkin kat sini creditors tu yang filekan JMO, dia tak mau nanti ada winding up contohnya. Okay. So that is the situation. Okay, dekat sini kalau kita nampak kat sini dia guna perkataan reasonable probability of rehab the company. Kat sini the court consider, dia kata the making of the order tu would be likely to achieve. Dia punya possibility jugalah perkataan likely tu kan. Mungkin boleh capai salah satu purpose ni. So kalau yang dekat sini rehab the company, yang kat sini dia guna perkataan survival of the company. So sama je, betul tak? Dia boleh teruskanlah the company tu. Yang ni or juga kan kat sini. Or part of his undertaking as a going concern. So sama dengan yang ni, betul tak? Okay, then yang kat sini kalau ada scheme of arrangement under 366 tadi. Yang kat sini. So kalau ada rearrangement for example has been made before, so the court consider that the order tu will serve the arrangement tu, then the court will also, sebab bila ada arrangement yang macam tu maksudnya there is a possibility to rehab the company again.
Faham.
Okay, yang kat sini adalah sama dengan sini, serving the interest of creditor better than in winding up. So yang kat sini a more advantageous realization of the company's asset. then on winding up. Kat sini dia general lah, asset tu mainly adalah untuk bayar creditors, betul tak? Bila ada rearrangement yang macam ni, concern dia lah adalah untuk bayar hutang. Sebab company bila dia tak boleh nak bayar hutang, dia face the risk of being wound up. Dia punya jumlah winding up ni cuma 50,000, if I'm not mistaken, dulu 5,000, if I'm not mistaken, recently dia jadi 50,000. So sikit je sebenarnya jumlah, nanti kita tengok winding up tu. Ya, to confirm lah. Saya terlupa berapa jumlah dia. So maksudnya bila a company is unable to pay his debt, dia tak bayar dia punya hutang, so they may be subjected to proceeding for winding up. So winding up process dia, maksudnya the business will end, so everything will cease. Okay.
Faham.
Okay, that's good. So to macam conclude tu tadi, so basically sama lah on the part of the director, the creditors, dia akan tengok consideration yang sama, and the court pun akan tengok the same consideration when it's making the order. Okay.
Okay. Thank you,
Okay,
madam.
that's good. That's good, Wafi. Okay. Alright, so that's it for today. Sampai dekat 2 jam juga. Okay, so please use the tutorial time to make a discussion and to upload your your chart showing the differences. Okay. Okay, thank you so much. Saya ambil ni juga. Saya ambil apa dia punya copy join info kat sini kan. Okay. Aina, please. Alright, so that's it. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, madam.
You're welcome.
Thank you, Doktor.
Thank you, madam.
Yeah, you're welcome. Yeah. So,
Thank you, madam.
you're welcome. Yeah. Saya stop record.